Just briefly, a little bit about HFS Milbourne. If you could go to the next slide, please, Helen. The business has been established since 1986, and we cover all areas of financial advice relating to private client, employee benefits, and professional services. Now, we're fully regulated by the Financial Conduct Authority to undertake all areas of financial planning, investment management, and that is on a whole of market basis, which is very important. We've had a long association with Surrey Law Society and deal quite extensively with law firms in most areas, whether it's family law, private clients. There are advisors who are resolution accredited, members of STEP. I have the qualification for the Society for Later Life Advisors, and we've sponsored Surrey Law Society and Guildford Chambers for many years. One area which might be of interest, particularly for you, is we have a specialist now who's a tax specialist for the United States, and this covers divorce work. So if you do come across clients who are dual nationals, have relations or connections with America, then please consider us. The chap's called Adam Smith, and he's recently joined Smith & Williamson. HFS Milbourne was acquired by Tilney Smith & Williamson March last year, so we've been part of them for just coming up to a year now, and that's created quite a huge platform for us to be able to provide services in many different areas, certainly areas that we didn't used to be able to provide them in HFS days. There are 265 or more financial planners, 290 investment managers, and we now sit on probably 56, 57 billion pounds worth of assets for our clients. So a decent firm with the full range of services, and I look forward to helping you with that in the future. Moving on to today's session, we have Martin and Rashanda providing the full detail of the thing, and the seminar will consider the statute of the no-fault divorce and its provisions, including what will come into effect and when, so that you as practitioners can answer clients' questions about the proposed changes and know what to expect. Martin has an established practice in property, family and licensing law. Martin's career in the law began when he qualified as a solicitor in 2006. His interest in advocacy led him to obtain his higher rights of audience in 2010, which gave him access to complex cases in the county and high court. The move to be called to the bar in 2011 was a natural extension of his commitment to advocacy as a speciality. Rashanda was a court advocate prior to joining 33 Bedford Row and was instructed in over 650 cases prior to accepting tenancy, giving her experience far beyond her year of call. She combines a strong focus on client care with thorough preparation, persuasive advocacy, and clear practical advice. She's instructed repeatedly by solicitors with outstanding testimonials from both lay and professional clients. Can I pass you now over to Martin, who will go through the full session on no-fault divorce work.
Thank you very much. Thank you for that introduction. If I may just start with the first of our slides, and really what I really want to start with is the background to how we got to where we are now. The Matrimonial Causes Act 1973 came about after much public consultation and involvement of the Law Commission and a special working group headed by the then Archbishop of Canterbury. It introduced only one basis for divorce, which was that it has irretrievably broken down and crucially could only be proven in one of 5 ways. These were a mix of fault and no fault factors. This was a huge and dramatic reform. So what does our current situation look like? The blame game. Well, mostly it's the blame game. And usually someone has to be at fault. Everyone here will be very familiar with these 5 grounds. it was widely considered at the time of being introduced that separation within 2 years would be the most used, and it was for a time where things may have appeared somewhat more civilized. It allowed for financial relief to get underway, and before you knew it, the 2 years was over and the parties could get divorced under 2 years of separation with consent. It sounds nice in theory, but however, with hindsight, we obviously now know the problems inherent with that approach, as the parties more often than not use it for their own advantage in seeking financial settlement. Equally, it allows for a strong aspect of control by one party. After a period of time had passed, the more readily adopted approach was to get a divorce as soon as possible, and then deal with financial resolution after. This is the approach we are still using today. Apply for decree nisi, thereafter issue financial remedy proceedings, and then the decree absolute, which completes the process. To do that, the parties need grounds that are available immediately, which are unreasonable behavior and adultery. Both these fault-based grounds are the most commonly used today. So what does this mean? It means that someone has to be at fault. It can mean anger, frustration, and hostility. It means that the parties cannot move on until one party takes the blame, or the matter proceeds to trial to determine the facts. Either way, that leaves a bitter taste for the parties involved. So what are the problems with the current law? It seems very obvious now, but remember, the law hasn't been changed for 50 years. Society has moved on significantly since then. None of the current grounds allow for immediate divorce without allegations of fault. If the couple have not been separated for more than 2 years, they cannot get divorced without one party being blamed for the breakdown of the marriage. So in essence, there is an opportunity for the respondent to defend. It is not a quick solution. Also, the parties need to sort out the finances, and the likelihood of that happening while the grounds for divorce is in dispute are extremely slim. Of course, the other issues are the costs escalate, hostility between the parties escalate. A further concern is that the proceedings may be used by a perpetrator of domestic abuse to continue the abuse, and this is unfortunately too common. And of course, we cannot ignore the knock-on effect on any children of the marriage. And this is what we see happening, sadly. We are in a profession where we see hostility every day. Very rarely do people come to us because everyone is sensible and able to agree. One thing we see day in, day out is what hostility in proceedings does to the children of the family. Sometimes our client or the spouse is so full of anger, they completely lose sight of the fact that children are becoming collateral damage. In many sets of proceedings, there will be children at proceedings allied alongside the divorce. Contested divorces very rarely, I might even say never, help the children because hostility is just too high. The question, of course, is, does the current reform help them really? To a point, yes, because it stops things getting escalated unnecessarily, because financial remedy proceedings can do that on its own. We know that being in proceedings is harmful for the children. We know the delays that the courts have. No set of proceedings are going to conclude quickly. And when parents are at war, the children are in the front seat. So we acknowledge that instructing solicitors are usually on the front line trying to mitigate this by including what they believe will be sufficient detail to get a behavior-based petition through the court without it turning into a witch hunt against the respondents. So I guess the question is, why is reform needed? Well, there are many obvious answers. Better for the family dynamic when children are involved. Some of you may see celebrity couples that seem to navigate divorce so well, like Gwyneth Paltrow and Chris Martin. If only they could all be like that. Most of our clients, I guess, are like Kim and Kanye, arguing it out. It should be noted that the UK is not spearheading the reform into effect. What I mean by this is that the so-called no-fault divorce is not new. Other countries use the no-fault divorce. For example, Scotland already has it where a couple can go through a no-fault divorce after 1 year of separation. And there are over 9 out of 10 divorces granted on the grounds of separation. This law, this new law, will also limit the ability of one party to challenge a divorce, which in some cases, under the current law, has allowed domestic abusers to exercise further coercive control over the victim. One of the issues of concern is regarding the current software. I know of extensive problems some of my instructing solicitors have had with the current system in place. As soon as it becomes not straightforward, the online system doesn't like it. You have to call the administrator or the courts. You can never get through to anyone, and it goes on and on. It is a system and law that is outdated and is in desperate need for change. But alas, on the horizon came the case that accelerated the process towards reform. Owens and Owens. So this case is really the straw that broke the camel's back, because reform was brewing for a while, but this got us to the goal and actually got things moving towards reform. So just for the background, for those that are not aware, Miss Owens said she wanted to divorce Mr. Owens on the ground that he had behaved unreasonably. Mr. Owens was having none of it. Her application, I believe petitioned in May 2015, was not any different to most other applications, stating the marriage was such that she could not reasonably be expected to live with him anymore. Similar to most other unreasonable behavior petitions you would have drafted. Mr. Owens contested this. The judge at first instance said that Mrs. Owens had exaggerated the context and seriousness of the allegations, and that her husband's behavior was the kind to be expected in a marriage. The court found no behavior that Mrs. Owens could not reasonably be expected to live with, and therefore the marriage could not be said to have irretrievably broken down. Mrs. Owens' petition was therefore dismissed. Mrs. Owens appealed the decision. However, the Court of Appeal returned to the question enshrined in statute. Did Mr. Owens behave in such a way that the petitioner cannot reasonably be expected to live with the respondent? The Court of Appeal was satisfied that the judge at first instance had correctly applied the law, and Mrs. Owens' appeal was dismissed. But Mrs. Owens was persistent. Not satisfied with the Court of Appeal, she took the matter to the Supreme Court. They issued its decision on the 25th of July, 2018, 3 years later. Now, considering the court delays we are currently having, I'd say that was rather quick. However, 3 years is a long time to be legally bound to someone if you don't want to be. The Supreme Court had reluctantly decreed that Mrs. Owens wasn't entitled to a divorce and must remain unhappily married until 2020, when she will have lived apart from her husband for 5 years. This is because she hasn't been able to satisfy the court that her 39-year marriage had broken down irretrievably as a result of her husband's behavior. Now, whilst the Supreme Court judges agreed that it was a troubling case and their decision left them feeling uneasy, they recognized that it was not for them to change the law laid down by Parliament. Their role was only to interpret and apply the law which was handed down to them. As we know, the court can't change the law, and it was what it was, a distinctly unsatisfactory state of affairs, a relationship that had broken down, but the parties had to stay married. Not an ideal situation. Resolutions, the Association of Family Lawyers and the government recognized that the decision was not right. By September 2018, the government had reacted and launched a consultation paper. The first stage to change something into law, it sought to remove fault-based approach and stop another party to contest it. By April 2019, the government announced commitment to introducing no-fault divorce. There has been a long wait to get a date for when this would be enforced. And finally, we know that on the 6th of April 2022, your clients can apply for a no-fault divorce. Later than expected, you might say, but finally here. It must be noted that the new law hasn't gone through without support from some judicial heavy hitters. And part of the support came from none other than the Supreme Court Judge, Baroness Hale, who has been an advocate of no-fault divorce coming into law. She described at the time the case of Owens and Owens as troubling because it was a situation they were stuck in. No one would take the blame. The Law Society has also been a long supporter for divorce reform from as early as 1996, and even lobbied for change in March 2017 during the case of Owens and Owens. So resolutions, the Association of Family Lawyers were also very much in support. So we ask ourselves, why the delay? Everyone involved agreed change was needed, but for it to take 4 years to come into force is quite some time. That said, the last 4 years have been used by the government to try and streamline the divorce process before the legislation change came into effect. The new online platform makes petitioning for divorce easier and quicker, and the whole process takes place online. There are exceptions, which we'll go into later. This is an overhaul of the law and process of how we do it. Of course, as we know, nothing happens quickly in the legal system. But the system is live now with groups that have been working with it, ready for launch on the 6th of April. And the feedback is that it is a much easier process to use and considerably quicker. The obvious knock-on effect makes divorce much less hostile, less expensive. Court time opens up more. Court time opens up more time, hopefully, to reduce backlog and get matters listed quicker. In June 2020, ministers announced the Divorce, Dissolution and Separation Act 2020, permitting separating couples to get a divorce, civil partnership dissolution, or legal separation, without being required to rely on one or more grounds for divorce. The long-awaited Act for no-fault divorce will effectively remove the fault element and is due to come into law on the 6th of April, 2022. It provides a 26-week period between commencement of divorce proceedings and the final divorce order being made. Although in reality, most divorces will take longer because of procedural steps and court delays, but at least this should minimize it. Now, this is a short timeline showing the journey of the Act as it has come into effect. Now, at this juncture, I will now pass you on to my colleague, Rashanda, who will deal with the new reforms in more detail. Thank you.
Thank you very much. So one of the changes that is coming out is the terminology we're going to be using. The new court language will be changed to something, I suppose, a bit more modern. And if we look to the slide, what we now call a divorce petition will become an application for divorce order. Decree nisi will be changed to a conditional order for divorce. Decree absolute will be changed to a final order of divorce, and the petitioner will become the applicant. So really, we need to look at how this is going to work. Instead of new legislation writing a new law for divorce in the 21st century, the 2020 Act amends the 1973 Act. It's impossible to see what the new law is without going back to the detail of that Act, and that's a huge pity. The Law Society did argue for a freshly worded, more easily understood law. That hasn't occurred. They have introduced a new minimum overall time frame of 6 months, so 26 weeks. This is made up of a minimum period of 20 weeks in divorce and dissolution proceedings between the start of proceedings, which is when the court issues the application, and when the applicant or applicants may apply for a conditional order. And the current minimum time frame of 6 weeks between conditional order and the final order. And this is to ensure that there's a period of reflection and where, I suppose, divorce is inevitable, provides a greater opportunity for couples to agree some practical arrangements for the future. Importantly, the 6-month period of time runs from the date that the papers are filed with the court or logged into the system, not from when they are served on the respondent. And of course, that is a hugely controversial issue because it may mean that the respondent have far less than a month's notice before they end up getting divorced. So 20 weeks after the filing of the papers at the court, and presuming the respondent has been served at some stage, the applicant can apply for first degree of divorce. We know that right now as decree nisi, but it'll be soon to be known as the conditional order. 6 weeks after the conditional order, the applicant can apply for the final decree of divorce. We know that as decree absolute. It will be known as the final divorce order. It's far from clear why these separate decrees with this separate timetable have been retained in this new law, but let's go on to the practical changes this makes for you. One of the very, very helpful provisions is that service by email has been added in accordance with Rule 6.7a. Email is no longer substituted service. It is a primary form of service. You can apply for an extension of time to serve under Rule 6.6b. One of the best elements of the new law is to recognise that some couples may want to apply jointly for divorce. It may be one of the last things they actually do together. So the new law allows for joint petitions. Both can go and apply. Even if one person applies for the original divorce, or even if both did, both can either apply for a conditional order or either. Now, I know that some lawyers, especially some who I know are on this webinar, have found themselves in a particular pickle where the applicant has deliberately halted the divorce process and flatly refuses to apply for decree absolute. You have to write to the court with a statement attached and so on. This completely removes the need to do that, which is going to be obviously very helpful when you're in that tight spot. One of the provisions in the existing law, which has for decades been a bit of a dead letter, I'd probably put it like that, is the Statement of Reconciliation. You will know that's a document filed by you saying that they've discussed prospects of reconciliation. Although some people, I know, go through this in quite a bit of detail, it is, in my opinion, a slight pro forma document filed at the same time as the divorce. There was an argument to scrap that, as it shouldn't form part of, modern divorce law, but it still survives and it is still required. So more practical changes. So proceedings that have been issued by the court on or before the 5th of April will continue to progress under the existing law we have now. That's whether they've been submitted digitally or whether they've been submitted on paper. These applications will not be impacted by the new law. Applications submitted under the existing law that are not issued by 6th of April, they will be returned to you or the applicant, depending if they're on their own. They will need to complete a new application under the new law on that process and on the new forms, which leads us on to where we are now. So the new forms in draft have been released to you already. You will probably start getting yourselves familiar. These, of course, must only be used from the 6th of April, 2022. Do not use them before, they will not mean anything. For applicants who start a joint application but find themselves in a situation where they're unable to continue with it, perhaps the relationship's deteriorated or they're just not taking those necessary steps, it is possible to switch the application from joint to sole. This can happen at conditional and final order application stage. To do this during a paper application process, applicants use Form D84 and D36A to proceed solely at the final stage. Where a joint applicant wishes to proceed as a sole applicant at final order stage, they must give 14 days notice to the other party. Online applicants will follow the guidance on the digital system. This should guide you through it. We have the D8 for dissolution, the D8B, D36, D36A, and D84. They're all on the slides. They can be released to you afterwards, but you should have them. They've been released. What also has been released is the Family Procedure Rules Amendments Statutory Instrument. They have put in the amendments that they've made in red, which makes it very clear as to what they have actually changed. You won't need to spot the difference as you go through reading 2 documents. You will also be able to see a revised Part 6 and Part 7 of the Family Procedure Rules and the amendments to the practice directions, which are consequential to the Act. It makes many updates in relation to service by email, and it incorporates that in very clearly. So this is a screenshot we've taken directly from the information pack that was released, and it's really helpful in outlining the process regarding joint applications. And really, it's quite self-explanatory. In theory, this shouldn't trip up your application. Just to run through the provisions on timing again, probably the most controversial element of this law as it went through Parliament was that the 26-week period only applies to the applicant. It doesn't apply to the respondent. That 26 period, as you know, is divided into the 20 weeks from issuing. Then it will give you the opportunity to apply for the conditional divorce order. Once granted, another minimum of 6 weeks before final divorce order can be applied for. That's when they can finally get divorced. The respondent needs to be fully aware of this in that final 6-week period. So the new technology, they have been changing the process and have implemented a new online platform, as you know. No longer complete a paper divorce petition, send it off, and then wonder where on earth it's got to, ringing up the court repeatedly. The online process should be quicker, easier. I say you can petition online, but really all the process takes place online, and I'll get into that in a moment. Sole applications can be made online through digital service or on paper using the D8 form. However, for your case, as solicitors, as you are representing the applicant, you must be using the digital service to make that application. The only exception they're allowing is when you are acting for both parties in a joint application, and in which case you can use paper form D8. When applications are submitted on paper, they will be scanned onto the system. There's a digital case management system for it. This will apply to applications for judicial separation, separation orders, and nullity proceedings. The digital system will basically ask for identical information that's on the forms and follow the same process. So as long as you have that information from your clients, you can fill in the same online. Applicants will need to supply documents to support their application, for example, their marriage certificate. These can be uploaded online during the application process. However, if there are issues doing that, you can submit them by post or email them to the court. Of course, this is something you already be aware, but if they are posted, they should be original or certified copies. They will not send you these back. You will have to apply to get these sent back to you. So it's something you'll need to keep on top of. What we do know from the updating guidance is that users of the digital service will first need to create an account or sign in to begin. That should be no surprise. After the application is issued, parties will be provided with a reference number and an access code to sign into the digital system. Parties will need to agree to receive emails to use the digital service. Those with access to the service will be able to see the documents and orders uploaded in relation to their case. So they should just be put on the system, which hopefully should streamline the process, and you'll know where you are. As with the current system, one of the parties can keep their contact details private if they need to. Respondents will be able to respond to the divorce application digitally if it has started digitally. Respondents will be provided with the access code, which is an access code plus a reference number, inviting them to the application. So of course, there are going to be potential issues with that. It's still not cheap. We believe it's still costing around £500. That's the administrative cost. Even though the cost of processing these applications will reduce, that saving doesn't appear to have been passed on. There are still help for fees. So sole applicants can still apply for help for fees where they've got little or no savings. They can get certain benefits. This also does apply for joint applications, providing both fulfill that requirement. But on the digital service, only applicant one, so the one person, can pay the court fee. They'll need to, it's not that both of them can make separate payments, only one payment can be made. It would seem, as one of the issues, of course, we've touched on, that the respondent doesn't get potentially an adequate enough time to know about the divorce application that's been issued. And that will be highly regrettable and very unfair on the respondents, because no longer will they have the opportunity to oppose a divorce. They will also have very limited time and opportunity to persuade the spouse not to proceed. And sadly, we can think of no more of a bitter environment than one spouse issuing a divorce petition, not telling the other spouse, not doing anything about it, and perhaps going on holiday, making plans and so forth. And then perhaps 16 weeks later, finding out that a divorce is imminent. We can only imagine the hostility that that would create, which is really what this act is trying to take away. That's going to overflow again into finances, into children, and really this must not happen. But it can be as a consequence of the way the new law and rules have been framed. And arguably that burden then becomes on you as legal professionals to try and make sure that divorces are served within the 28-day initial time period, and to make sure that this new act and how it's processed is a better way than the previous act. There will, of course, be a number of circumstances in which lawyers may decide to deliberately delay service. And one thing that will really come to mind is in the context of domestic abuse. That was cited in Parliament as the primary reason why respondents should not have the full 20 weeks notification. And of course, you will have to use your professional judgment as to when to serve, when is appropriate, how that's going to be helpful for your client, and so on. So let's play devil's advocate here. There are a lot of people that weren't for this. And there's a variety of reasons, one of which is that it suggested that couples will no longer work on their marriage because it's, too easy really to get out of it. Some cited other potential risks associated with making divorce more straightforward and more accessible, feeling that this could lead couples to opt for divorce as soon as difficulties arise, rather than taking the time to save their relationship, perhaps get therapy or whatever it is they need to do to try and save their marriage. But that's also why the primary reason why the period of reflection of 20 weeks has been introduced, and it will give the couples an opportunity to reflect and work through those difficulties before committing to a divorce. Others have suggested that it damages the sanctity of marriage. People will enter marriage very easily, knowing that they can just get out of it easily. And some may have a view that if someone has been subjected to unreasonable behavior or their spouse has committed adultery, then that spouse should have the opportunity of being held to account. And that's been another thing put forward. So whilst the Law Society expressed a support for the reform, it also said that the legislation could have been clearer, fairer and more accessible by reviewing the notice period and the financial proceedings. Something to bear in mind is, of course, that court fee and the fact that to look at this act, we need to look to the previous act. One thing that's really important, and it's something that as solicitors you'll really need to take into consideration, is that this is now the first time in English family law history where you'll be asked to jointly lodge a divorce petition for both parties. And that in and of itself shouldn't amount to, well, really may amount to professional challenges. It won't if it's a one-off instruction, but if each party is instructing a separate solicitor regarding financial or children matters, and then the parties agree to go ahead with the joint petition, they might not want to instruct a separate lawyer, but will both parties or both lawyers feel comfortable with one lawyer, then acting for them on the filing of a petition, and so forth. I mean, it's a situation that really is very new. You're going to need to take great professional care as to how you handle a situation like that, what conflicts of interest may arise. So is this the Holy Grail we've all been looking for? Probably not, is the answer. This isn't a miracle cure. This has taken over 50 years to create change and reflect on modern society. But divorce is always going to be something that's not easy. Emotions will always be running higher than normal to some degree. And to bear in mind, the vast majority of petitions are actually undefended. So even if a divorce is opposed, it still has to be approved by the court. But what this really will do is give a practical solution to a system that really was getting very outdated and should have been changed a while ago. And now I'm just going on to some questions. We did ask for questions to be pre-submitted. I'll just take off my screen sharing. Actually, I'll leave it on there. Pre-submitted. And we have about 8 questions, and we'll try and take some more. But if we don't, Martin and I are going to provide our email addresses at the end. This is a new law. It's new for all of us. It still hasn't come into force yet. If there are things we cannot answer, we will get back to you. So please do send us an email with any question, and we really will try and help. So I'm just going to go to my pre-prepared questions that have come in, and Martin, perhaps I can get the first one with you. I'm going to just put this onto our contact details for anyone to see if they want to email. Okay, one of the questions, Martin, that came in was, what process do we follow for cases where the client seeks an annulment?
Right, well, nullity applications must continue to be made using the paper application process, and that's using the D8N form. Joint applications continue to not be permissible for nullity proceedings. Whilst the Act did not make any substantive changes to nullity proceedings, there is a set of new forms for nullity which have been produced to account for relevant procedural changes. And these include a service and relevant new procedure rules, including those detailed on page 7 and 9, which apply to nullity proceedings, including the introduction of email service terminology, and they are detailed at pages 18 and 19. And B, you will not be able to use the new digital service for nullity applications. So I hope that answers that question.
Yeah, that does. That's the pages that are in the updating guidance that came out, and it was specifically referenced to those. So that should hopefully answer that quite quickly and quite easily. One of the questions that came in was about help for fees, and I think I already touched on that. Sole applicants can apply, joint applicants can apply. There is a link for that. I don't have it to hand, but if you email, I can certainly send that over. One of the other questions was dealing with urgent applications. Can the court deal with urgent applications? And I can quickly answer this because I just double checked as well. They can, but that's exceptional circumstances. I can't think of any that come to my mind, but if that does happen, and it may happen, you need to set those out in a letter addressed to the court and submit it with them. There's also an email address for that as to where to send that to, which I don't have to hand, but if you want it, please email me and I can get it and provide it to you. So another question that came up, I think we touched on it, Martin, but it was, what if my application was submitted to the court but not issued before 6th of April? And that's...
Yes, I think we touched on it. It'll be sent back, won't it?
Yeah.
I believe they've asked also for paper submissions to be submitted by, I think, the 31st of March.
Yeah.
In order to go through under the old law, is my understanding.
Yeah, absolutely. That's the date I've got too, so yeah. That's helpful. The other thing that we were asked is about the statement of reconciliation. Again, I think I covered that one. It's under Rule 7.3. It's survived the reform somehow. It's still there. You've still got to do it. Sorry, another question for you, Martin. I think we touched on this one as well. I think we're answering our own questions here, but is this a new act on its own for divorce?
Yes, isn't it? Yes, but it needs to be read, I think, in conjunction with the Matrimonial Causes Act 73. The new act has been written, and the Divorce, Dissolution and Separation Act 2020. But this is brief legislation, isn't it? This will also, though, include civil partnership dissolution as well.
Great. Another question we had. Oh, yeah. So are there any ways in which the divorce can be contested? So the answer to that is actually yes. It's extremely limited. So respondents can't dispute when the marriage has broken down, obviously. They can only dispute the application on a few grounds. So one of those is that they dispute the jurisdiction of the court. So the Court of England and Wales, for example, neither of them live here or got married here. They can dispute the validity of the marriage or civil partnership if it hasn't been legally entered into. If the marriage has already ended, been legally ended, then of course, that shouldn't be going through. It will also be possible to challenge proceedings for reasons such as fraud and procedural compliance. It's unclear how they want to go about doing that, but I think as we go on, we'll find out exactly what form the courts would like us to do that in. I think at this juncture, based on what we know, they're not quite sure yet. So another thing that came through, or something, this is something I added on just so in case anyone has a question on it. What if the parties change their mind about divorce?
Well, I think I can answer that. Well, that's why there is a cooling off period. And so if your clients or client wish to reconcile and stop the divorce, then they'll need to complete the form D11 and send it to the court. A sole applicant may withdraw at any time before service of the application on the respondent by giving notice in writing to the court. And that is rule 7.6,
Yeah.
not mistaken. If it is a joint application, both applicants will need to fill out this form jointly. And this is the same for both digital and paper applications.
Great. I know that we've got one question Q&A. I'm still screen sharing, so I haven't looked at it yet. But just before we do, I want to set everyone, this is all very new to all of us. If you do have anything as you go you want to ask us, please just get in touch. No question is too small. We're really happy to go through. If there's any questions that perhaps come up later, please let us know. What we are doing is offering, and we have booked in, presentations to do for individual firms that ask for it. We're happy to just perhaps do another Zoom privately for members of the team. We will be updating our presentation as things come into effect. So the more we know, the more information we'll collate and make it relevant for you. So we're happy to do that. I'm going to stop sharing so I can just see what question has come up. Just on the previous page, reference me. Oh yeah, sorry, I think that's a question about the fee. So I put, and I hope it came clear, it's around 550. I didn't put down the exact amount because I didn't double check it, but it's around that amount. What we were expecting to see was a much more reduced fee. It's cheaper for them to process, it's quicker for them to process. They just haven't done that. It's still around the same fee. So it's over £500, really closer to 600. Unfortunately, not much is changing in that regard. And it's a real pity, but hopefully with that extra money, the system can be improved regularly. Probably overly optimistic, but there we are. I hope that answers anyone's question. And unless there's anything else, I think, Martin, that's perhaps you and I done.
I think that's it. Yes, I think that's it. Well, thank you for inviting us.
Yes,
I'm most grateful for it, for the time.
Well, on behalf of Surrey Law Society, I must thank both Martin and Rashenda for putting forward what is fascinating, even for me, who's not a solicitor, and certainly builds into that expression, the devil is certainly in the detail, for something that is going to go on probably for a lot longer than the last lot of rules. Anybody who's been watching this today, I can confirm that we've recorded it, and a link will be sent to you shortly, so that you can go through the whole lot again if you want to. Can I also ask you to send any feedback to Helen, not just on today's session, but if there's anything that you would like Surrey Law Society to put forward as a webinar or as a CBD session. Helen's always very interested to build her menu to be able to be interesting for you and engaging. And there's no doubt that today's session was both of those. And I can only thank Martin and Rashenda once again. Thank you.
Thank you very much.